also have arguments, read briefs, have proceedings, apply law to facts, and try to issue commandments at the end, some of which are more and less binding than others. They're also out there doing that. They range from state courts to territorial courts to military tribunals to administrative agencies. So can they be doing that? After all, Article 3 vests the judicial power of the United States in the federal courts, which are appointed and confirmed and life tenured, more or less. And you have all these other things running around that don't seem to be pursuant to Article 3. And we've tolerated various versions of those things, again, going back to the founding and often before the founding. So what's going on? So it is important to distinguish things like the ability to adjudicate, the ability to apply law to fact, the ability to have hearings and say what the law means from the core of the judicial power being just the power to issue binding judgments that authorize the deprivation of life, liberty, or property. So many of the so-called legislative courts or so-called non-Article 3 courts are not courts at all. They're actually not issuing binding judgments. They can't deprive people of life, liberty, or property, or they have some other reason they're consistent with due process. A few of them are. A few of them do have judicial power. And for them, the key is to look at a different part of Article 3, or to look at a different couple words. The fact that Article 3 only vests the judicial power of the United States. So Article 3 does not vest the judicial power of other governments, of state courts, of foreign countries, of Indian tribes, and even of territories. So that's a lot. What do I mean by that? Where do I come down? So let's think about different kinds of non-Article 3 courts you might have heard of or encountered. There's one group of them that are perfectly constitutional because they exercise the judicial power of some other government. That is why we have state courts. The state courts in Texas exercise the judicial power of the state of Texas. That's perfectly constitutionally permissible because the judicial power of the state of Texas is different from the judicial power of the United States. Indian tribes across the country have their own tribal courts that exercise the judicial power of that tribe. Again, a separate government that has its own judicial power, not vested by the United States. The most controversial example of this are also territories. So the incorporated territories, the Northwest Territory, the Louisiana Territory, probably even the District of Columbia, although it's technically not a territory, have their own courts that have generally not been held to be subject to Article 3's requirements because they exercise the judicial power of the territory of Louisiana, the territory of Florida, of the District of Columbia. And those are their own governments with their own judicial power. So they can issue the same kind of binding judgments, the same kind of deprivations that federal courts can because they have their own governmental source of authority. So there's judicial power outside of Article 3. It's the judicial power of entities that are not the United States. Now, there are a lot of other entities, in many ways more important in these debates, that do not exercise judicial power because they are not vested with the power of some other government, and they're not Article 3 courts. These are, I think all the important ones are in the executive branch. So administrative agencies that engage in various kinds of administrative hearings, ranging from immigration courts to administrative law judges and social security cases and so on. They're not courts. They don't have the judicial power. So they only have the executive power. That means that their judgments are not binding in the same way that federal courts judgments are not binding. And it means that they can't actually authorize the deprivation of life, liberty, or property. Some modern cases do allow administrative courts to do that, but they're wrong to do so. And in fact, some of the traditions of the limits on administrative courts probably understand them better if we recast them this way. So there are administrative agencies, but they should not be depriving people of life, liberty, and property. They should be adjudicating public rights and other things where there's no deprivation of life, liberty, or property. Then there are military tribunals and military courts, which Professor Vladeck knows a lot more about than I do, and I've benefited hugely from his work in thinking about these. These also are not courts because, again, they're part of the executive branch. They're not part of the judicial branch. So they haven't been vested with any kind of valid judicial power. They are trickier to understand because they do and always have deprived people of liberty and even life. So they're a little bit of a puzzle under this theory, but they've been held to satisfy the requirements of due process back to and essentially before the founding. So they're permissible nonetheless. You can see them either as just they're permissible because they satisfy due process under a sort of independent tradition a tradition that's just part of the way the due process clause has been understood, maybe one that we should be re-understood, and maybe one that should make us a little more skeptical about overextensions of military jurisdiction today. There are early attempts to justify them on the theory that members of the military have sort of forfeited their rights to life and liberty by joining the military. So they don't really have the same privileges of life and liberty as civilians do. I'm not sure I'd go that far. I'm not sure that's right, although it's would be another way of making sense of the whole scheme. But those courts are executive power. So administrative agencies, executive power, military tribunals, executive power, meaning they don't have the same binding force, and they have a more complicated relationship to due process. The same thing then turns out to be true for throughout the so-called Article 1 courts, the tax court, Court of Federal Claims. Happy to talk about all of them if people want to ask questions, or if Professor Vladeck wants to pick on particularly tricky examples. But they too are not courts. They're part of the executive branch, thus limited to the due process and principles I've just described. So there's adjudication outside of Article 3, but it never exists. But judicial power doesn't exist in the executive branch. It only exists in other governments. The last thing I'll say about judicial power before hearing Professor Vladeck's thoughts and responses is there are several other important principles about the way courts function that are longstanding features of our system. And I am not sure whether it's best to read them into the judicial power or into some other part of the Constitution. One of those is the principle that courts proceed by finding law rather than make it, that their job is to apply law rather than to legislate. Another one is the principle that courts have to be limited to certain categories of cases and parties, that they have to have a proper party before them bringing claims about that own party's rights in order for the court to be able to hear it. Now that's the modern standing doctrine. I think it's plausible to think those might be parts of the judicial power as well. Part of what distinguishes judicial branch agencies from executive branch agencies. They've sometimes been put in other places, in other constitutional clauses, but it might be that they belong there as well. And I might be willing to defend that too, but I haven't decided yet. Thank you.
Okay, cool. Hi, everybody. Let me first say thank you so much to Will for taking the time for doing this. I know how Will wouldn't say this, but Will has a relatively young kid at home, and as someone with two slightly relative, well, now two, right? So we're
up to two. Yeah, we're following your footsteps.
Yes. So I am deeply sympathetic to the cost of this kind of adventure. This is also a real treat for me because I've been a huge fan of Will's work for as long as there has been Will's work, and so getting a chance to fight a little bit on territory that we have both written on is a real treat. Okay, so let me start with where I think Will and I agree, and then let me try to suggest why all of this matters, and then let me end up with where I think we disagree in a couple of places rather vehemently, or at least I'm vehement. Will is usually much more dispassionate. So let me start with where we agree. And the first place is I put in the chat the link to Will's Harvard article, which I really would encourage everyone to read because, even though I have quibbles with some of the takeaways, there's no question that we ought to be thinking more about the first sentence of Article 3 when we're thinking about questions about the role of the federal courts, not just in the context that Will's paper is mostly focused on, which is non-Article 3 adjudication, but just in broad. I mean, we spend so much time on the vesting clause of Article 2 and the vesting clause of Article 1. We really do neglect the vesting clause of Article 3, and I think that's a mistake. Because among other things, I actually think there's a more coherent story to tell about a number of justiciability doctrines if we actually think about those as exercises or constraints on judicial power, as opposed to what is a case and what is a controversy. That, to me, modern justiciability doctrine would have a much happier home textually in the first sentence of Article 3, Section 1 than in the first sentence of Article 3, Section 2. So that big agreement there. We also, I think, agree for the most part that the judicial power clause is both an affirmative source of authority and an important limit on authority for the federal courts. That just like the vesting clauses of Articles 1 and Article 2, insofar as we're ever going to sort of revive some kind of non-delegation doctrine, I suspect Will and I agree that there are some non-delegation points that might even flow from Article 3, Section 1, although we might quibble what those are. Finally, and this might surprise Will to hear, we agree that a lot of what administrative agencies and even some Article 1 courts do is not, in my view, an exercise of judicial power. Some Article 1 courts, and I'm gonna explain exactly. I draw the line in a different place than Will does, and we'll talk about. I suspect we will go back and forth about where I draw the line. Let me also try to situate why this matters. So let's start with the specific conversation about the propriety of non-Article 3 federal adjudication. As Will says, we've had it since the founding. And what I mean by that is, like, we've had courts-martial at the very least since the founding. The first Supreme Court decision expressly upholding a non-Article 3 federal court is United States versus 356 bales of cotton, known to history as Cantor, in 1828 or 29. I never remember which one it is. I don't really think it matters for these purposes. So they've been around forever. And there's, I am at least one of those who thinks that historical gloss has some bearing on this conversation. But in all that time, I think Will would agree, no one has come forward with a satisfying analytical explanation for why we allow certain kinds of non-Article 3 adjudication and not others. There's a great quote from Rehnquist's concurrence in Northern Pipeline in 1981 about whether there are these three neat categories, or rather ships on a judicial darkling plane crossing by night. I'm more into the crossing by night because Rehnquist is wrong. There are actually more than three categories. But then we get into, so that's sort of what, Will's paper is, I think, one of the most sustained and intriguing efforts in a long time to try to rationalize a lot of this stuff. I just disagree with how he rationalizes it, but I'm glad the effort is helpful, because I think, the Supreme Court has not had to explain in quite a while why any of this is permissible, let alone why some of it's permissible and some of it's not. And if anything, some of the court's most recent non-Article 3 cases, like Stern versus Marshall and Oil States Energy, are, to me, in some respects, deeply incoherent. So the effort by people like Will to try to actually put meat on the bone is enormously useful. Okay. So that's the nice part of the conversation. Then there's also the sort of beyond non-Article 3 adjudication. There's also the extent to which it's just helpful to have a theory of what judicial power is in any number of other contexts. And I say this mindful of the fact that some of the folks watching this are in my federal courts class right now. That we ought to actually have some sense of what courts are supposed to be doing when they're exercising judicial power. And actually, the Supreme Court does not very often stoop to define what makes something judicial versus non-judicial. The closest they've come in a long time is a case I was on the short side of 3 years ago, the Ortiz case, where Will thinks they actually also got it wrong, but for different reasons. So that's the sort of why all this matters. Now we sort of talk about 5 areas of disagreement between Will and me. So this is disagreement number 1. So Will says state courts exercise state judicial power, to which my response is they exercise state judicial power and, I think in some circumstances, federal judicial power. That is to say, there are circumstances where the Supreme Court has held that state courts actually have to provide a remedy, even if state law does not require one. I'm not sure how in those circumstances state courts could be said to be exercising state judicial power as opposed to federal judicial power, but maybe Will just thinks that the federal Constitution also circumscribes, also commandeers state judicial power. That may be sort of a sort of low-hanging fruit. Bigger objections, too, with regard to territorial courts and DC. So Will's argument, just so far as I understand it, if I get it wrong, Will, slap me around, turns on the notion that the territorial courts in DC and in Guam and in the Virgin Islands are exercising the judicial power of the territory. And to me, that presupposes that the territories have sovereignty. Because unlike states, territories, federal territories, have no sovereignty. They are the federal sovereign for constitutional purposes. Double jeopardy applies as if it were the federal government. Heller versus DC, you don't need to incorporate the Second Amendment before you apply the Second Amendment to the DC Code, because the DC Code is federal law for constitutional purposes. And so I guess I just am not clear how institutions that have no independent sovereignty could nevertheless retain their own judicial power that is somehow not part of the judicial power of the United States. Three, on military courts, and I think Will knows that this is where I feel the most strongly, because where you stand is a function of where you sit. So I resist quite strongly the argument that military courts are exercising executive power, just going on what Will described as the two most important features of judicial power: the power to issue binding judgments and the power to authorize the deprivation of life, liberty, and property. That's exactly what military courts do, up to and including the death penalty. And so I just, the notion that military courts are exercising executive power, I think might have been true for a large swath of American history. So until 1950, there was no such thing as a military court. There was just a court martial, which was a purely administrative executive branch entity with no judicial review, with no meaningful statutory control by Congress. One of the real innovations of the Uniform Code of Military Justice in 1950 is to create a judicial system in the military, or at least what's called, in deference to Will, what's called a judicial system in the military, complete with a court at the top that's supposed to be staffed by so-called Article I judges, the Court of Appeals to the Armed Forces. More than that, right? In 1983, Congress puts the Supreme Court above CAF. And in 1987, CAF holds that courts martial can prosecute even non-military offenses committed by service members. And so even if we think of courts martial at the founding as executive branch tribunals prosecuting uniquely military offenses in a context in which there's no judicial review, that's just not the military justice system today. Now, one response might be, ergo, the military justice system is unconstitutional. I think that would surprise a heck of a lot of people. Will replies at least a bit that maybe this is permissible because these military courts satisfy due process. And I think the tricky part there is what processes due has really evolved dramatically over time, where the process that was due at the founding was exceptionally limited in a context in which those courts could only prosecute on-duty military offenses committed by service members, right? Today, when military courts can prosecute off-base, off-duty offenses, not just by active duty service members, but by retired service members who are effectively civilians, I think that puts real pressure on the argument that this is executive power. Because for all intents and purposes, these are courts, these are entities that are enforcing normal civilian criminal statutes against people who are effectively civilians with consequences that look just like the consequences of our civilian criminal justice system. And I think it's hard to characterize that as purely executive power, at least as I understand Will's definition. Fourth, with regard to some administrative agencies, right? So I don't know if this is a disagreement with Will so much as just a sort of suggestion that Will's argument runs headlong into a longer line of Supreme Court cases than perhaps he'd like. The Supreme Court has held on a number of occasions that there are some contexts in which administrative agencies can issue binding preclusive judgments that deprive litigants of property. Now, I take Will's point to be yes, and those are all wrong. But I think there's something to be said for the notion that if we're using historical gloss to justify some parts of this argument, that historical gloss might matter too. All right, and then finally, last but not least, and this will, I think, animate the point where Will and I agree and disagree about Article 1. So Will says the key is to go, the sort of the line is public rights, right? That public rights are things that these bodies can adjudicate without exercising judicial power. And the critical point to me is, and Will should correct me if I'm wrong, that makes sense in a world where we're understanding what is a public right, the way that the Supreme Court did up until 1985. That is to say, where public rights are dependent upon waivers of sovereign immunity or other unique historical carve-outs where there was no expectation of life, liberty, or property, where everything was a function of government beneficence, and where the only reason why we allowed non-Article 3 review was because non-Article 3 review was thought preferable to no review in a context in which Congress had the power to provide for no review. If that's the argument, I think there's a lot to be said for that. And indeed, I'm on record as thinking that the Supreme Court took a wrong turn in 1985 in expanding the scope of public rights. I just want to stress what the implications of that would be. Because in a world in which we go back to the pre-1985 view of public rights, just about all of the bankruptcy system is unconstitutional today. Much of the patent system is unconstitutional today. And, that's not to say, therefore, Will is wrong. I love arguments that most of what we're doing is unconstitutional. It's just to say that I think there's a lot of uphill swimming to carry the notion that public rights, as the Supreme Court currently understands them, would support this distinction, because I don't think they do. So in sum, right, and just to sort of try to tie all this together, I think it's really important for us to be having a conversation about what the judicial power of the United States is. I think Will and I largely agree, with the exception of the military, about what judicial power is. I think most of our disagreements are about what the United States is. And that may be sort of a narrower point to end on.
This is great. So this is a great way to put these points, and let me just take a few of them. Start it basically in the order Steve gave them to me. So state courts, you're right, Steve. I don't think they exercise federal judicial power, even when they're being forced to decide cases by federal constitutional law. I'm not sure those cases are all right, but even if they are, I think their best rationale is that they say the Supremacy Clause of the Constitution specifically calls out state court judges as being bound thereby by the Constitution. And this creates a special federal constitutional commands for state judges about how they exercise their state judicial power. And it requires them not to discriminate against federal claims, and sometimes even to give federal claims preferred treatment, in much the same way that the Equal Protection Clause requires them not to discriminate against African Americans or others. And they're still exercising state judicial power when they do that, just pursuant to federal constitutional commands about how they do. Territorial courts, you're right. I mean, there's a funny question about the nature of the project here. You're right that territories are not sovereign. And so it's weird to talk about the government of Florida, back when it was a territory, or now the government of Guam, as having its own power, when in the deeper sense, all of its power comes from the federal government. But I don't think sovereignty is the test, in part because I'm doing my best here to figure out what Chief Justice Marshall could possibly have been saying or thinking when describing the constitutionality of territorial courts. So if this were, had he gone the other way, had he said territorial courts have to be pursuant to Article 3 because all their judicial power ultimately comes from Article 3, I might say fair enough that this is a interpretation you could see either way. But given his reading of the ambiguity, this is my view of what's happening. It also has the advantage of explaining the rest of territorial governance, because territorial legislatures are also don't fit into any of the vesting clauses, and they're exercising something. It seems to be the legislative power of the territory they're a part of. But here I'm partly doing my best to channel Chief Justice Marshall, one of my favorite tasks of constitutional law. I'm not sure what I would have done in 1828 myself. Military courts, I'm not resistant to the view that post 1940 military courts are unconstitutional, or maybe it is a severability view. I mean, maybe they really exercise judicial power, and therefore we ought to, as a matter of severability, interpret them as having life tenure, which would fix all the problems. Interpret them as being Article 3 courts, to their own surprise. I'm not totally averse to that view. The question of how to think about the transformation is a hard one, and I guess this goes to the final points about administrative agencies as well. So what I see as having happened with administrative agencies is there were two traditional categories to explain what administrative agencies could do. Either traditional public rights, things to which you had no right at all. The legislature, the executive could do it on their own, and so you had no right to complain about whatever procedures they used to do them. Or things where there was effectively no preclusive character. The agency issued a kind of did something, but there was effectively no review in an Article 3 court, which is also permissible. And as I see it, starting with Crowell versus Benson a little before, but especially starting with Crowell versus Benson, the Supreme Court kind of smushed those two categories together and then watered them both down. So your average administrative agency now deprives you of something that's more than a public right, but still seems to the Supreme Court to be kind of lower class and therefore entitled to lesser protection. And then you get some kind of judicial review, but not de novo Article 3 review that you'd be entitled to. And the court kind of thinks, well, those two things together add up to make it enough. But it seems to do so under the misimpression that it's doing something connected to the history or tradition it's citing. Like it says, oh, these are long-standing categories, and then it kind of misinterprets both the categories and then multiplies them and gets modern administrative agencies. If the Supreme Court wanted to say, look, this is just like a new thing. These are not the traditional non-Article 3 categories, but we got a new tradition now. The administrative state's been here for 100 years. So we're just breaking free of those rationales. I'd have nothing to say about that other than the standard questions about originalism. So I don't have nothing new to say about that. Like, fair enough. What I worry about is the falsely trading on a sense that these non-Article 3 courts traditions go back to the founding and are inevitable and they've got to be there, and then applying misbegotten, new labeled versions of them as if it was doing the same thing. And that's part of what I worry about in the military court system too, right? So if the Supreme Court would say, look, military courts were executive power up until this point, but then we created judicial power, and it's not Article 3 judicial power. It's fine for it not to be Article 3 judicial power because we say so. More power to them, I guess. But that's part of what troubles me on both counts. So whatever the answer to how much, should we get rid of 20 years of history or 100 years of history? I, at a minimum, think we ought to be clear about who's making up the rules and when.
So let me just be quick, because I'd love to throw this open to the students. Let me start again with where we agree, right? And I think the perhaps the most profound agreement is that the Supreme Court is often, if not usually, way too superficial in its discussion of this topic. And repeatedly, I don't mean to put words in your mouth, but I think
two law professors in federal courts can always agree on that proposition, I hope.
Fair enough. But the superficiality here is actually acutely specific about taking what was settled in 1830 as therefore applying a fortiori to 2020. Without taking account of dramatic changes in the nature of the thing undergirding what's settled, right? So territorial courts look very much the same as they did way back then. Military courts and administrative agencies don't. And the profound jurisdictional and structural changes in the nature of adjudication these bodies are doing, in the volume of adjudication they're doing, and in the gravity of the adjudication they're doing, ought to have at least required the court to revisit this at some point. And, in the military courts context, Will, as you know, the court has never grappled with the question of how Solorio, the 1987 decision that throws open courts martial for all offenses, no matter their connection to the military, calls into question the sort of originalist, courts martial are okay because they're prosecuting military specific offenses committed in the military. Those are not the same. So common ground that like the court is at least partly responsible for the extent to which this whole area is under theorized. Let me throw in one more point that I think we probably agree on, although neither of us have said it overtly, which is that the court is also inconsistent methodologically in these cases between formalism and functionalism. Where the court, at least, if not Will tries to be more consistent than the court, but the court at least applies what is necessarily a functionalist approach to non-Article 3 adjudication, but then relies on formalistic principles to cabin it. And so, for example, the Chief's opinion in Stern versus Marshall is a remarkably formalistic opinion about a system that could only exist in a world where we've already reached a functional accommodation about Article 3. Right. And so I always have trouble reconciling those two things. Like, how can you be sort of half formalist and half functionalist? And then really quickly on, I think we're probably the commandeering state. I mean, obviously I agree that the Supremacy Clause allows for commandeering of state courts. I think, and this again goes to sort of cases that I think are right and you may not think are right. I think a case like Montgomery versus Louisiana is not just a commandeering case. Which of course may be why you think it's wrong. But I think, in a world in which Montgomery is right, Montgomery is creating affirmative obligations on state courts to exercise a particular kind of judicial power that the state court might itself have tried to disclaim. And I think that's way in the weeds. Let me go sort of on bigger categories. So on territorial courts, I mean, what are legislatures doing in the territories? Well, so let's back up a second, right? DC did not have a legislature until 1970, right? That DC had no territorial government to speak of, right, until the Home Rule movement. And so, and then everything in DC flows from the Home Rule Act, which is an act of Congress. So I actually think it's pretty straightforward that every single thing the DC Council does and everything Mayor Bowser does is simply exercising authority delegated to them by Congress. The trick, Puerto Rico, I think, Will, is actually the hardest case because Puerto Rico has its own constitution, which none of the other territories do, or at least none were given the power by Congress to have their own constitutions. And so Puerto Rico, I think, has the strongest claim to some independent font of authority. But here's the weirdest part. Puerto Rico does not have a non-Article 3 federal court, right? The local courts in Puerto Rico are courts created by the Puerto Rican legislature, and the federal court is an Article 3 district court. So Puerto Rico would be the best argument, but Puerto Rico doesn't even come into our discussion. Whereas like the Guam legislature and the Northern Mariana legislature are just exercising power delegated in Title 48 of the U.S. Code. And so I just have I just struggle with the notion that that power can be cleaved. The really messy question to me is a question the court sort of started to answer in the Puerto Rico Finance Board cases about whether federal officials in the territories are not actually federal officials. And I always thought the hardest question in that case was whether a Guam district judge is actually doesn't have to be appointed by the president, right? Like something like that. So there's a broader theoretical problem. I just have I don't know how you can slice the apple where the territories are federal sovereigns for double jeopardy purposes, that's Sanchez Valle, but they're not federal sovereigns for Article 3 purposes. Like that seems a weird split. On military courts, life tenure, I think would giving military judges life tenure would raise some serious Article 2 problems. But let me just sort of take one step back and try one last provocation before we throw open questions. I think the missing link, and your point about sort of Article 3 really drives us home. We haven't talked about jury trial. And it strikes me that one of the real sort of thorny knots in this whole conversation is how the right to a jury trial intersects with the right to an Article 3 court. Because, military courts sort of by tradition, although ironically no express Supreme Court holding, are not bound by the Sixth Amendment jury trial right. Right, Brennan famously in Grand Financiera finds a way out of the hole for bankruptcy courts by saying, obviously, if it's a public right, it's not protected by the Seventh Amendment. Which is perfectly circular. And so it seems to me, Will, that like one of the questions then becomes, in your view, right, are there a whole bunch of contexts in which litigants are being deprived of constitutional jury trial rights? Because it seems to me that, to sort of take your theory to its stopping point, the answer ought to be yes.
Okay, that's great. Should we get questions? Should I try to handle them first?
You're the guest, you pick.
I'll just say I think the circularity of the Seventh Amendment is basically correct. I think the circularity of the Seventh Amendment is basically correct. I think the Seventh Amendment applies to suits at common law, and I think if something is validly placed outside of the judicial system, so it's being handled by executive power rather than judicial power, it makes sense not to describe it as a suit at common law. I mean, that the thing, like the suit at common law is from my little bit of looking at the phrase, seems to be a reference to things that happen in courts. And so it's actually the circularity is exactly correct. If you can validly make it not a suit of common law, then so it no longer applies to it. Now that just gets us back to the original question of what does the judicial power need to apply to and what does it not need to apply to? Mm-hmm. The thing about military courts that I find harder is that Article 3 itself has its own jury trial right. The requirement that all crimes except impeachments be by jury. And the fact that you can make an exception for impeachments is interesting. Suggests that all means all.
It's not just that. You also have the grand jury indictment clause of the Fifth Amendment.
Right.
Which exempts cases arising in the land or naval forces from grand jury indictment, which we would usually be, if you're expressly exempting them from one protection, seems to imply that they're otherwise covered.
Yeah, so I don't know what to make of that, and I don't know how to understand the meaning of jury and whether to think that having a panel, other service members would be enough to satisfy the jury requirement, or what to think about that.
So 10 seconds. I'm writing a paper about that.
Okay.
So I have a paper about how even though the Supreme Court assumes, but again has never actually decided that the Sixth Amendment doesn't apply, military courts have very quietly created a sort of a poor cousin of the jury trial right through the Due Process Clause, because today in a court martial, a service member has a heck of a bunch of rights vis-a-vis the members, the jury, that military courts say are due process rights, but that in every other context are understood as Sixth Amendment rights.
Send it to me.
Well, thank you both, professors, for offering your thoughts. We do have some questions trickling in, so I'd love to dive right into those with our time that's left. One question from Evan mentions, considering that Article 1 vesting is phrased as all legislative powers herein granted, compared to the Article 2 and 3 judicial/executive power of the United States language. Since we are all textualists now, what's the takeaway from the difference in language with respect to the Article 3 vesting and scope?
I think the standard textualist catechism is, that's to clarify that Congress can only exercise the specific legislative powers enumerated in Article 1, Section 8, and incorporate with the necessary proper clause. It doesn't have sort of the generic form of the legislative power that legislators traditionally had. It doesn't have inherent powers, although the Supreme Court's given it some. Whereas the executive might have some residual powers not enumerated in Article 2, and judicial powers not really defined in Article 3. So again, it carries with it the traditional powers. So it's really a sort of enumerated powers principle for Congress. I've never been quite sure if that holds up, but that is the standard answer I'm supposed to give, I think.
I think where it runs into trouble, Will, is just how much inherent power the courts have granted Congress, right?
Oh yeah, I'm against all that though.
Well, fair enough.
But yes.
But I will just say, I mean, so I think, I mean, to Evan's question, like I do think it, I think it says a lot more about Article 1 than it says about Article 2 and Article 3, which I think is not inconsistent with what Will said. I will just say though, we are all textualists now, quip, since I can't help being the crypto-fascist tree-hugging, liberal in this conversation. We're all textualists, except here we are having a whole conversation about thousands and thousands of adjudications every year that are at least superficially difficult to reconcile with the plain text of Article 3. And so let's just, one of the reasons why I think non-Article 3 courts is really fascinating is because one who is a real dyed-in-the-wool formalist and who maybe doesn't share Will's view of the judicial power would have real problems with most of this. And so in my federal courts class, I assigned Gary Lawson's article on the limits of formalism vis-a-vis Article 3, Article 3 and Article 3 courts. And Gary Lawson, who is an incredibly bright, thoughtful, and consistent guy, right, I think points out how it's hard to be a textualist when it comes to Article 3.
All right, thank you for your thoughts.
We've stumped everybody. There are no more questions in the Q&A.
Well, I can offer one, and this may just be partially my ignorance because I shamefully haven't taken a Fed Courts class yet.
Boo.
Joke's on me, I guess. So I'm just curious, this may be more of a question for Professor Bode. With respect to the non-Article 3 courts or agencies that don't issue binding judgments, can you elaborate a little bit about sort of the enforcement process on any decisions that they hand down? What does that look like when you don't have what you would consider a binding judgment on a litigant?
Sure, and I mean this actually is complicated, obviously from agency to agency. But so take for example something like the Court of Federal Claims. They have the power to adjudicate claims for money damages against the United States, and because the United States has sovereign immunity, you can't sue the United States for money damages anywhere unless the United States has said you can. And to oversimplify, they've largely told you to go to the Court of Claims if that's what you want to do. Court of Claims is not really an Article 3 court; it's executive branch agency, so it's really adjudicating the public right to this kind of money against the United States. Now, the judgments it issues they give you what you want in a way, which is it will issue a judgment entitling you to money that has already been appropriated by Congress in the judgment fund. So they conclude, oh, you're owed this money by us, then you can go cash the check. But it's not something that binds the determinations don't constitutionally bind the executive branch in the same way that a Article 3 court's adjudications would. So if Congress wanted to set up a proceeding in which in which that entitlement to money was only at the discretion of the president, or there were limits on the way it could be paid. That would be fine because it's in the executive branch. There was an early sort of 19th century saga about an attempt to create a court of claims with an attempt to create it under Article 3 that ran into problems of this kind, because for an Article 3 court, you can't say this judgment's only valid once the president's kind of decided he likes it. But you can do that in terms of how you structure a administrative agency.
Okay, thank you. Anything to add to that, Professor Vladeck?
No, I mean, I think this is actually, I think, one point where I think Will and I are on totally common ground, and indeed where I think his article is really important, which is just reminding everyone that a heck of a lot of what agencies are doing, and what at least some Article 1 courts are doing, isn't what the rest of them are doing. And that we do have a tendency to conflate them, and I think that's unfortunate, because there are some pretty important differences between, for example, inter partes review in the patent system, and the denial of a refund claim by the tax court.
Yeah. So can we talk about advisory opinions for a second?
Yeah.
Since you mentioned it. So I like the idea of saying that say advisory opinions are the reason that federal courts can't issue advisory opinions is because it's not the judicial power. What I worry about is state courts. So I think there are lots of state courts that have been issuing advisory opinions, since the founding, or have had it as a.
But so I don't know the cases. Are those? I don't know which clause of the state constitutions that power is derived from, right? Because that would be an interesting question.
It would. It'd be interesting to go look at them. My worry is, I think the Massachusetts Supreme Court issues them, and I don't think it's been given anything other than judicial power, which might mean that judicial power is defined differently under state law than under federal law.
Well, it has to, it has to be, right? Because the judicial power of Massachusetts extends to cases that are not cases under the judicial power of the United States.
Well, does it? I mean, so it extends to different heads of jurisdiction. Those are separately vested. So, but if the judicial power is the power to adjudicate whatever cases are within your jurisdiction, with jurisdiction determined by something else, then it can have a uniform meaning across the two. But I don't know, or maybe we should see the Massachusetts Supreme Court as having two powers: the judicial power and the separate advisory opinion power, which is just its own weird thing. But Christian Burset at Notre Dame has been doing some interesting work on the sort of campaign against advisory opinions in courts around the globe at this time, which I need to look at more carefully. But it seems to me like this is perhaps a broader implication if it's true.
Do you think a state court answering a certified question from a federal court is an advisory opinion?
So I didn't used to, and then I had a student who was actually related to a state court judge who had repeatedly taken that view and refused to answer any certified questions on the grounds that they were advisory opinions forbidden by the Michigan Constitution.
What if Congress allowed for temporary transfers of cases from federal court to state court?
Yes, that would accomplish the same thing, right? So I think answering certified questions is okay, in part, although I think some of the states, as I understand it, so every state decides on its own what certified questions it's willing to answer, and often impose some conditions, like the federal court has to tell us this question is actually going to be determinative, which might be designed.
Don't make us get dressed up for nothing.
Well, and that might be designed to meet the separation of powers concern. That is, if you're just asking, we don't have the power to answer. But if you tell us this will resolve your case, then okay, we have the power to do it.
I mean, the other thing that's interesting is, some state constitutions have much more explicit non-delegation provisions.
Yes.
It's like Nevada, for example, has a provision specifically about not being able to delegate judicial power, which I think is an interesting contrast. But I mean, I think the broader problem, like I've been thinking about this in the context, Will, of the justiciability of impeachments, which for obvious reasons, and right. The question is, I have this weird view that Nixon versus U.S. is rightly decided, but for totally the wrong reasons.
Isn't that the standard view?
Is it the standard view? I guess if it's standard view, then maybe I'm not as weird as I thought it was.
Well, I think so, but what are your wrong reasons? Let's see.
So I mean, first, I don't think that the word, as my federal court students will have already figured out from yesterday's class, I don't think the word sole is a textually demonstrable commitment of anything, and I don't think the word try lacks judicially manageable standards. And so I think the two grounds Rehnquist actually offered for invoking the political question doctrine were both bogus. And I think his policy arguments were incredibly compelling.
Yeah.
And so to me, the right way to think about Nixon is that, you know, the judicial power is part of a system of separated powers where there has to be checks on judicial power. And allowing the judicial power to extend to impeachments would eviscerate one of those checks. And then the tricky part becomes, is that therefore just a limit on judicial power to review judicial impeachments? Or is that necessarily a limit on judicial power to review all impeachments?
Okay, so good. So I also don't think Rehnquist's textual arguments are compelling, but I don't like the policy arguments that much either. So I had the rare experience of thinking Justice Stevens might have been onto something more than Justice Rehnquist in making what I think was just an originalist point, that we know it was a basic intentional choice to relocate impeachments from courts to the legislature. And even if they didn't correctly use the magic words to say to say that the relocation was preclusive, that was plainly what they thought they were doing and trying to do. And so
see also the jury trial clause of Article 3.
Yeah, well, if I were looking for the magic word, it would be judgment. Judgment in cases of impeachment extends to et cetera, suggesting it's the same kind of binding preclusive judgment that courts get to issue, and that's the clue that the impeachment is really subbing in for a court and doing what a court would do.
But we end up in the same place, right? Which is that there's textual support. So it is in some respects a textual commitment, but not the text Rehnquist relies upon.
Yes, your policy argument seems to me has broader ramifications, like for judicial review of jurisdiction stripping or court packing or all the other impeachment's one check on the judiciary. So if the general principle is we should not have judicial review of checks on the judiciary, it seems like that would extend.
Right. I didn't mean to. I think I may have overstated it in trying to simplify it. No. The notion was just that the power of courts to defeat an impeachment, right, seems like a much more aggressive exercise of check eviscerating power than the power to review a statute circumscribing their jurisdiction.
Yes.
So where does that leave us? I guess Stephen, are there a couple more questions in the chat?
Yes, we have had a couple flow in the last couple of minutes, so we can try to hit some of those. One from Joseph asks, does the degree of Article 3 appellate review vary between Article 1 courts, territorial courts, and military courts? And does the degree of review available change the analysis of the validity of those courts? To either professor.
It does vary, and it varies fairly dramatically. And so let me just take a couple examples, and Will might have other ones that come immediately to mind. So Congress treats the territorial courts as if they were state Supreme Courts. I'm sorry, let me back up. Congress treats the DC territorial courts as if they were a state Supreme Court. And so therefore, the Supreme Court only has appellate jurisdiction to review the DC Court of Appeals in cases where it would be able to review a state court of last resort. The other territorial federal courts are all district courts who are subject to plenary review by their courts of appeals. And so that's, of course, one pretty big difference. One other big difference, and this is sort of something near and dear to my heart. The Court of Appeals for the Armed Forces, the Supreme Court only has jurisdiction over the Court of Appeals for the Armed Forces in 4 sets of cases the Court of Appeals for the Armed Forces hears. Capital cases, cases certified by the Judge Advocate General of the Service Branch, cases in which the Court of Appeals has granted a discretionary petition for review, like a cert petition, and other cases in which the court has granted relief. The case that exempts is a case where the Court of Appeals for the Armed Forces has denied a petition for review, even if it raises a federal constitutional question. There's actually no mechanism for the service member to seek cert in that context. And then with regard to the other Article 1 courts, I mean, I'm trying to think, are there any other Article 1 courts that the Supreme Court reviews directly?
No.
Right, it's the DC Court of Appeals and CAF, and that's it.
Yeah, everything else it's funneled through something else.
Yeah. That wasn't always true, right? So there was a weird period of time where there were some Article 1 courts that could be reviewed directly in the Supreme Court. The Court of Private Land Claims being my favorite in the obscure pantheon of old Article 1 courts. But today it's just the DC Court of Appeals and CAF.
Yeah. Court for the Indian Territory also, I think.
Yep.
Yeah, that's right. And so this is a funny, of the many federal courts professors who have perished trying to come up with some theory of how all this makes sense, one of the most prominent theories is that non-Article 3 courts are okay so long as there's an adequate kind of Article 3 review. And this has been relabeled in many different ways by Dick Fallon and others. I don't think this works. I think this often requires, and maybe another point Steve and I agree on, exactly the variety that Steve just described of all the different kinds of review you get for all these different kind of courts. Seems to me that whatever is explaining this practice, that's not doing the work, and it doesn't make any sense to me that the permissibility or impermissibility of your first level court can be cured by kind of some non-de novo review in federal court later. Nobody thinks you can have criminal prosecutions outside the military in non-Article 3 courts and then satisfy it by having review later, and nobody knows why.
Stephen, can I take a shot at tying a couple of the questions in the chat together? Is that okay?
Sure, that would be great. I was going to take your recommendation on how to try to cover the most ground.
Yeah, so I'm going to try to tackle Jim and Warren's questions, and then if we have time, because I want to let Will weigh in too, and then if we have time for Shane's. Courts-martial rest on a combination of the make rules power, to Jim's question in the chat, and the exception in the grand jury indictment clause for cases arising on the land or naval forces. The Guantanamo military commissions, which we haven't really talked about, are a strange non-related example where it's not rules and regulation in the military. It's actually some combination of the war powers and Congress's power to define and punish offenses against the laws of nations, combined with an atextual exception to the jury trial clauses that the Supreme Court articulated in 1942 in a case called Ex parte Quirin, which, as Justice Scalia so understatedly put it, not this court's finest hour, in Scalia's words. And so the short version of that is, as a result, there are textual questions about the scope of both the Article 1 grants and the Article 3 limits that have been answered in some cases, but not all. And so let me just to put this directly. I mean, I'm in the middle of litigating two cases, one in the DC Circuit, one in the Court of Appeals of the Armed Forces, about retirees and whether retirees can be tried by court-martial for post-retirement offenses. And in both cases, right, there's both an Article 1 question, whether retired service members are still part of the land and naval forces, and there's a jury trial question, right, whether these cases actually arise in the land and naval forces. So there are constitutional questions on both sides of that apple. And then to Warren's question, the short answer is no. The Supreme Court has granted cert to CAF 11 times in the 38 years it has had the power to do so, which is a lot less frequently than any other federal court of appeals, and even some state courts. For various reasons, the Supreme Court actually doesn't take up that many cases from CAF, which is a source of significant consternation in the military justice community, because there are actually a whole lot of cert-worthy cases. So, Will, that was a lot. I didn't want to. I wanted to give you a chance to jump in.
No, sure. So one interesting thing about the military commissions is, so in Ortiz, this case that Steve litigated, where the court said that he was right and I was wrong about the nature.
I lost I lost the rest of it.
You lost things your clients cared about, but you won the federal court's question. Yeah, about the Court of Appeals of the Armed Forces exercising judicial power and being in the or exercising judicial power, power of a judicial character, I guess, as they put it. Justice Thomas, who said that, he said the Court of Appeals of the Armed Forces is judicial, but he reserved in a footnote the possibility that that military commissions, rather than courts martial, would be executive power or war power as well. So even, I don't know how many other justices have thought about cleaving those two things apart, but he seems to think they could be different.
Well, can I back? I mean, so Will, I guess I'm not sure. I have made a bad habit of asking this question too often in my federal courts final. I'm not sure courts martial are judicial, right? That is to say, to me, the reason why I think Ortiz is an easy case is because the Supreme Court's not reviewing a court martial directly; it's reviewing CAF, right? And it's courts martial are actually not created by Congress. They're created by They're created by the Secretary of Defense under authority delegated by Congress. Right. And so one of the weird things here is that I actually think it's still very much unsettled after Ortiz. If, for example, the Supreme Court could issue an original writ of habeas corpus to a court martial as an exercise of appellate jurisdiction.
Okay,
right?
Good.
As opposed to an original writ of habeas corpus to CAF, which I think has to follow from Ortiz.
Yes. Okay. Good point.
But then to pivot that to the military commissions, right? The military commissions have a parallel structure where the trial level courts, I think there's no question that those are not, that those are like executive power-ish things. But now you've got an Article 1 intermediate appeals court, the Court of Military Commission Review, and then the DC Circuit, which I think we all agree is exercising the judicial power of the United States.
That one's clear. Yeah. Yes, this is right. And that actually, good point. And that also suggests, again, on the, funny way to cure this problem, if I were right about it, is I think you could cure the CAF problem entirely by just giving the CAF judges life tenure instead of the 15 years. Well, and I'm trying to write about severability now. It wouldn't be under current principles of severability. It wouldn't even be a crazy severability rule if you said we have to give up one of the two things: the requirement that CAF judges lose their office after 15 years, or a Supreme Court appellate review. Which one would Congress rather give up? It wouldn't be crazy to say, oh, Congress probably wouldn't mind if they just kept saying the difference in 15 years in life is probably not that important to Congress.
And just one more really big quirk, and then I know we're over time, and so Shane, the short version is the short version of Shane's question is probably no. But Shane, I'd love to follow up with you on that offline. Just Will, one other quirk, and this is actually my favorite footnote about CAF that raises all kinds of Fed courts questions that no one has ever actually really thought about. The CAF statute says that in a circumstance in which there are insufficient number of active or senior CAF judges to fill the bench, which is 5 judges, right? Because unlike SCOTUS, they try to fill the bench when someone's recused. The statute says in a circumstance in which there's an insufficient number of judges to form a quorum, the deficiency can be made up by Article 3 judges. Who are temporarily assigned to the position by the Chief Justice, right? So a sort of a sitting by designation situation, and that strikes me as preposterously unconstitutional in at least 3 respects, including the specter of a mixed panel with an Article 3 judge and an Article 1 judge, which of course was where we were. What the Supreme Court already balked at that in the Nguyen case in 2003, right? So. Yeah. Let me say, CAF is rather understudied as a source of real Fed courts problems.
Has that happened in an important case?
So it's happened so CAF went from 3 to 5 judges in 1991. Right. There were a couple of cases before 91 where the whole panel was recused. And so they brought in 3 Article 3 judges. And no one thought to challenge that to this. And even better, that was before 83, where you couldn't have appealed that to the Supreme Court.
Right. Okay.
So I'll say that when we're talking about the judicial power of the United States, right, I think the part of why I love Will's project and part of why I think Will and I may never agree on what the actual answer is because I think the military, it's not, Will's response, I think, is right, which is that maybe there's a whole lot of the military justice system today that actually doesn't hold up to sufficient scrutiny. I think the larger point is that's no court is ever going to say that. And that's not to say Will's therefore wrong. It's just to say that for practitioner focused approaches, right, the sort of the upshot may be finding more creative ways to attack the jurisdiction elsewhere.
Fair enough.
All right. Well, I know we're running a little over on time. I do thank both Professor Vladeck and Professor Bode for hanging on with us a few extra minutes to get through some questions. It's been a great discussion. I really hope that our audience has enjoyed some of the back and forth. For those UT Law students who are not members of the Federalist Society and wish to learn more about the organization, we've dropped some contact information for our membership chair, Henry Humphreys, into the chat, along with a brief pitch for next week's event on presidential power, Framers v. Now. Again, thank you all so much for being here and for listening in tonight. Thank you to our guests for joining us, and we hope to see everyone next time.
Thanks, Stephen. Thanks, Will.
Thank you.